one is this?
Good morning, Mr. Chair. I'm presenting AB 5256. First, I would like to take the amendments in the analysis as author amendments. AB 256 expands the prohibition against willingly, willfully, and intentionally tampering with evidence to include digital images and video recordings. In 2000, AB 1993 was signed into law, making it a felony for a peace officer to knowingly alter, place, or move physical evidence with specific intent to wrongfully charge another person with a crime. AB 1993 was inspired by the Los Angeles Police Department Rampart scandal. The objective of the bill was to preserve evidence. However, with the increased use of technology, this law has not been updated to include evidence on personal mobile phones and other electronic devices. Electronic evidence is now common and deserves to be included in order to prevent wrongful arrests and convictions. This recording capability has provided the public an opportunity to lawfully monitor instances of police misconduct. For example, May 2013, police in Bakersfield temporarily confiscated the mobile devices of two witnesses who recorded police beating a 33-year-old father of four. The victim of the police beating subsequently died. The police returned the devices with the video of the intent deleted. Increasingly, as the public captures police practices on video, it's critical that we send a message that altering or deleting these videos will not be tolerated. I ask for your aye vote. With me today is Ignacio Hernandez from the California Attorneys for Criminal Justice.
Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of CACJ. We are sponsors, as the author indicated. I thank the author for bringing this bill forward. We've worked with him to address what we think has been a gap in current law. Back in 2000, this legislature adopted the underlying felony for peace officers, and it was done as a result of really kind of tragic events in Los Angeles where there were a handful of officers who were running rampant and they were planting evidence on individuals in order to set them up to be prosecuted. And if you look back at the news headlines, you will find that those officers were put on trial, but for perjury and for filing a false police report. They were not tried for planting evidence because at that time there was no felony on the books for making it unlawful for a peace officer to manipulate physical evidence to set someone up or plant evidence. So in 2000, the legislature adopted the bill to make sure there was a felony. We're doing two things today. We're updating that statute to make clear that digital images and video are covered by that. And we're also making clear that the ability for someone to take a video of an officer, interaction between an officer and the public, would be covered by this felony. Again, this is not an indictment of all law enforcement officers. Believe it or not, this may be hard to believe, I have a number of very close family members that have been law enforcement their entire lives, so I've learned a lot about the challenges on the front lines. But I also learned that for those handful of officers that do commit these offenses and do really tarnish the badge, that there needs to be accountability. And so this bill addresses that. We have no opposition. We have some friendly faces in support, which I enjoy, and I ask for your support on this bill.
Mr. Chair and members, Corey Salzello on behalf of the California State Sheriff's Association, here in opposition. No, I just didn't want to have a heart attack here. This is we're not usually on the picture here. Take a picture. We're not usually on the same side of the table or at the table at the same time, but we'll tell you that law enforcement doesn't condone the type of activity discussed here, and are pleased to support Mr. Jones-Sawyer's bill.
Really appreciate that. Thank you. Other witnesses in support?
Micah Doctoroff, American Civil Liberties Union of California, in support.
Marla Marshall on behalf of Sheriff Bill Gore and the San Diego County Sheriff's Department in support.
Very good. Now we will hear from any witnesses in opposition. There being no witnesses in opposition, we'll next hear questions and comments from members.
I have a quick suggestion. I would like to ask for amendment consideration that we include others that may be associated with sworn officers, like staff or non-sworn personnel, who also tamper with this evidence, to be included in this statute.
Very good idea. Yes.
Good. Other comments and questions?
We'll work with him to do that.
All right. So by recommendation, let's see, motion, we need a motion on the bill. Moved by Madam Vice Chair, seconded by Member Lowe. The motion being moved and seconded, we will now, Madam Secretary, you can call the roll.
Quirk?
Aye.
Quirk, aye. Melendez? Melendez, aye. Gonzalez? Gonzalez, aye. Jones Sawyer?
Aye.
Jones Sawyer, aye. Lackey?
Aye.
Lackey, aye. Lowe?
Aye.
Lowe, aye. Santiago? Santiago, aye.
Yes. Was there a question?
Oh, I did accept the amendments, so
Okay, very good. Thank you.
Excuse me.
For the record.
It's very difficult to amend a bill or to rewrite the bill in committee if we would have to determine what the exact language is. So
the proposed amendments.
From the committee.
Well,
All right, we'll take care of it later. Right now, we
three
will.
different people telling me three different ways to do this.
All right. Perhaps, Chief Consultant, you can be just a little bit more clear. What is accepted and what isn't?
are you accepting the proposed amendments from the committee?
Yes.
Yes. And as far as the suggestion of Mr. Lackey, that's something that will be considered in the future?
Yes.
Okay.
All right, so I think that's clear then. And I think we have the committee amendments accepted, and Mr. Lackey having brought up a very good idea. So again, the bill is out, and I want to thank you all.
Now,
All right,
now we have
now we
AB
have-
267.
267, item number 9.
Criminal proceeding statement. Let me start by stating that I accept the committee's amendments as author amendments and appreciate the consultant for his hard work on this issue. AB 267 requires the court to inform the defendant that accepting a plea or a subsequent felony conviction has various collateral consequences. Those collateral consequences include, but are not limited to, ineligibility for enlisting in the military, ineligibility to own or possess a firearm, loss of federal financial aid if the felony was committed while the defendant was receiving financial aid, potential diminished parental and child custody rights. According to the New York Times, fewer than 1 in 40 felonies now make it to trial, as compared to 1970, when the ratio was about 1 in 12. Being charged and convicted of a felony can have dire, long-term consequences, and much too often, defendants are not advised of the long-term repercussions. AB 267 is not a new concept. It is simply expanding upon existing law. Currently, judges are required to administer an advisement regarding possible deportation or exclusion from admission to the United States for the conviction of an offense. This bill only adds to the advisements and will inform defendants of the collateral consequences of accepting a plea and becoming a felon. Lastly, we are currently working to narrow the list of consequences to ensure that the most serious advisements are read by the court. Here today to testify in support is, again, Ignacio Hernandez, who is representing the California Attorneys for Criminal Justice, and Lizzie Burchin for the Center for Juvenile and Criminal Justice. I respectfully ask for your aye vote.
2 witnesses, 2 minutes each.
Morning, and thank you for the opportunity to speak in support of AB 267. My name is Lizzie Buchan. I'm a policy analyst with the Center on Juvenile and Criminal Justice. CJCJ works to reduce unnecessary incarceration and foster long-term public safety in California, and we pursue this mission through policy analysis and direct service provision. So we offer several programs that provide employment readiness training to people who are formerly incarcerated, which serve several hundred adult clients every year. The people we serve come to us voluntarily because they are committed to rebuilding their lives and to begin working, living as working, productive, law-abiding members of the community. But no matter how motivated they are all dragged down to some extent by their felony convictions. Their convictions significantly interfere with employment prospects, can make them ineligible for GA, SSI, financial aid, as the Assembly member listed. There's a very long list. The collateral consequences are numerous and severe. And nearly all of our clients, like nearly everyone else who has been found guilty, took a plea deal. And it's safe to say that the vast majority of them, if not all, did not fully understand the severity of the consequences that would flow from that guilty plea and that will haunt them for the rest of their lives. Yesterday, I met with our Homeless Employment Collaborative program, which helps homeless, formerly incarcerated people find and maintain gainful employment. I spoke with one of our clients, a young man who had been training to be a firefighter when he was charged with a felony. He pleaded guilty so he could get out of jail and complete his training, only to find out that he could no longer be a firefighter as a result of his conviction, and he could no longer be a long list of other occupations. Another client took a plea deal so he could get back to his family. He did not realize that his entire family would be evicted as a result of his conviction. He said that if he had known that, he would have gone to trial. These are just a couple of our clients. We hear it all the time from the people we serve, how surprised they are by the impact their felony convictions have. None of them could have imagined that the felony conviction would make it so difficult and touch so many important parts of their lives. When asked why they took the plea, many say the same thing. They just wanted to go home. Most of our clients are too poor to post bail, so they are incarcerated pre-trial. They want to get out of jail. They want to go home to their families. And when they're offered a plea deal that will allow them to do so and are ignorant of the lifelong consequences, it can seem like a reasonable decision. But unfortunately, it's usually a very poorly informed one. And it's possible that even if they had fully appreciated the consequences of the conviction, many of these people would still have pled guilty, and that may have been a good decision for them. But it's also possible that some of them would not have taken the plea and would have chosen to have their day in court, or they may have worked to secure a different plea offer that would have avoided certain consequences. So if they would have made different decisions had they been more informed, the criminal justice system is being undermined, and that's very worrisome. Pleading guilty to a felony is a very serious decision. Defendants already have the right to know the direct criminal penalties for their convictions, and often the collateral consequences are much more severe. Defendants need information about these consequences to have the full picture of what may occur as a result of any guilty plea so that they can weigh the costs and benefits when making their decisions. This is critical to a fair and transparent justice system.
Yes.
I ask for
Okay. Oh, perfect timing. All right. Other witnesses in support?
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, Statewide Association of Criminal Defense Attorneys, co-sponsor, ask for your support.
Thank you. Other witnesses in support?
Micah Doctoroff, American Civil Liberties Union of California, in support.
Jesse Stout, Legal Services for Prisoners with Children, in strong support of the bill, especially the voting rights advisement. Excellent.
David Bouchot, Legal Services for Prisoners with Children, in strong support as well.
Very good. Next, well, any other witnesses in support? Witnesses in opposition?
Good morning, Mr. Chair and members. Good morning. I'm Lexi Howard with California Advocates on behalf of the California Judges Association. Regretfully, we are currently opposed to AB 267. We have been working with the author's office. The committee's recommended suggestions we agree with. However, regretfully, they're not sufficient to remove our opposition. The current advisements that are currently required include immigration, maximum punishment, and constitutional advisements. We understand from judges that those take a minimum of 4 minutes to administer, and we're very sympathetic to due process and the need for defendants to understand what they're pleading to and what those consequences are. However, we are very concerned about the burden on the courts of the additional time, and that list may not ever be inclusive enough to provide, for instance, one of the witnesses indicated all of those protections. I think I heard housing, that's not noted. So concerns in general about the increased burden on the courts without a consequent benefit for the defendants.
Very well put. Thank you. Other witnesses in opposition? All right, then. Questions from the committee?
Thank you,
Madam Vice Chair.
Thank you, Mr. Chairman. Isn't it the burden on the defense attorney to notify their client about these consequences? Nobody wants to answer my question.
I guess I should
Great.
address that. Ignacio Hernandez again. Generally, yes. Well,
isn't that what your attorney's for?
Attorneys have ethical obligations to provide, strong defense for and representation for our clients. Part of that is obviously to discuss the options available to them. Within that discussion, and I've done this many years ago before I was lobbying, where we discuss what especially the direct legal consequences are of a plea. We also talk generally about other impacts. So we are subject to certain ethical obligations. We are subject to an ineffective assistance of counsel claim. There's accountability for us. Where this bill is helpful is that oftentimes, one, you have someone, like in the situations that were described by the previous witness, who has not had the opportunity to have a full discussion with an attorney, public or private. And oftentimes folks do show up in court, think that if they just plea out, that everything will be fine. And so that is a major sub-universe that would be addressed by this bill. Secondly, oftentimes there are plea deals that are negotiated. And so while we may have sat down and had a discussion with our client about the consequences in our office or perhaps in the county jail, circumstances can change. Sometimes the DA will show up to court, we'll have a discussion in chambers, and there'll be an offer for a plea deal. We'll have to immediately sit down and talk to our clients about it. We run through everything that we can. Having this additional layer to ensure at that moment of plea, which is how it's being amended, is going to be helpful to make sure that they hear everything. Our obligation is our obligation. But in an additional 4 minutes, I counted it at 2:20, but that's fine. We'll go with 4. Let's say 6 minutes. Would be extremely beneficial for those folks, just to make sure. Hearing it a second time is not harmful. In fact, hearing it a second time is very beneficial because it is a tough decision. We have clients that go back and forth about whether or not they want to plea. There's a reason why judges have to ensure that this is a voluntary plea. And so this is just an additional layer of protection for folks going forward. And if we're serious about reducing recidivism, then this is important. And again, as far as the extra force expense, I'm sympathetic to it. I'm supportive of additional court funding. I think the opponents know that. But I also know that courtrooms, there's downtime in courtrooms, and we're going to maybe fill up a little bit of downtime, ensuring that someone isn't subject to a lifetime implications of their plea without full knowledge. And even if it's heard a second time, we think it's beneficial. I'll leave it at that.
All right. Any other questions? Assembly Member Gonzalez.
Just to follow up on that, Ignacio, and in particular, this in no way relieves a defense attorney's obligation to adequately advise a client, especially of immigration status. I mean, given we have a bill on post-conviction relief, I'm concerned that the more we pile on somehow allows a judge in the future to say they were notified, and yet in this bill, first of all, the language says may. I think the ineligibility for citizenship is kind of hidden. I'm a little concerned that we're in fact creating a system where immigration status, which of course is a huge concern and often misunderstood by the courts, the defense attorney, the client, that's getting watered down in this. So I just wanted to understand or somehow be affirmed that this in no way relieves a defense attorney from adequately informing their client of a possible probable deportation now under new acts if they plead to a felony.
Yeah. Just for clarification, if I may, Mr. Chair, through the chair, our understanding of this bill is that the standalone ethical obligations of an attorney are in no way altered, increased, or decreased by this bill.
Very good.
I have a quick comment,
Please
if I could,
do.
real quickly. I'd like to just remind the audience that when somebody represents themselves, I think the term is going pro per, and it's very rare in a felony situation. And I'm definitely going to support it at this stage, but I would ask that you consider prioritizing these items so that there isn't an undue burden. We're trying to really maximize the court's time because they are very overburdened, and we want to make sure that we efficiently use their time and respect that in the interest of justice as anything else. Thank you.
It's fair.
All right. Other comments? You may close.
I've heard all the comments. They're very good comments, and we'll make sure, especially prioritizing, ensuring that we do not become a burden to the courts. The author will respectfully take all of that into consideration as we move forward. So I respectfully ask for your aye vote.
Very good, then. I will recommend an aye vote. I think Assemblymember Lackey summarized my concerns. Certainly, we respect very much the Judicial Council's concerns. We're particularly concerned that the direct consequences be discussed. We have obviously concerns about immigration that's covered under other law. I know that having worked with you for 2.5 years now, that you will take this all into account and as this moves forward. So thank you very much for your good work on this. Can I have we haven't had a motion on this yet. Move the bill by Gonzalez, second by Lackey. Very good. There's been a motion and a second. Madam Secretary, please call the roll.
Quirk?
Aye.
Quirk, aye. Melendez? Melendez not voting. Gonzalez? Aye. Gonzalez, aye. Jones Sawyer?
Aye.
Jones Sawyer, aye. Lackey? Aye. Lackey, aye. Lowe?
Aye.
Lowe, aye. Santiago? Santiago, aye.
I want to thank you very much, and we will now go on to Madam Vice Chair's bill. And that's item number 5, AB 160. 150? Well, excuse me, 150.